for the program. Today, we all are gathered here for the Impact Lecture series under the Ministry of Education Innovation Cell and AICTE organized by IIC SKNSITS. Initially, it is my privilege to offer my welcome to you all. Honorable Principal Dr. M.S. Okale Sir, Dr. Sagar Dage Sir, Head of Computer Department Dr. Sarah Patil Sir, Head of IT Department Dr. Priyanka Hale Ma'am, Head of First Aid Department Professor G.V. Khandekar Sir, IIC SKNSIT President Dr. Vaishali Reddy Ma'am, all faculty members and all the students present for this session. Now, I request Dr. Sarah Patil Sir to welcome Dr. Sagar Dage Sir. We have planned to conduct the session on the overview of patent application process. Today, we have with us Dr. Sagar Dage sir. He is the Assistant Director at JSPM Group of Institutes, Pune. He has 7 years experience. He has completed PhD from IIT Roper. He has arranged many faculty development programs related to co-curriculum development and academic administration institute. He has developed and implemented necessary systems oriented academic administrations, policies, procedures, and regulations of an autonomous institute. Now I request you, sir, to handle the session.
Okay, good afternoon. Okay, so I know this is afternoon session. Uh, so generally afternoon session this kind of board, right? So because I was also student and students, so I know that generally afternoon session is a little bit boring session. Students are not interested, but that's fine. I like to make it very much interactive. So I am not a seasoned professional who is experts in the patent and all those things, but I have some experience in the patent filing procedures. When I was working in the one company after my masters, so there we filed for number of patents. It was associated with the wind turbine. So you might aware about this Suzlon company. So we were competitor of Suzlon and we filed 4 patents which was not able to file in the Germany. Our designer team was in the Germany, so they couldn't able to file in the Germany. So then we took it over from them and then we tried to file it and successfully file that patents by doing some changes. So that is my first, we can say that first hand experience with the patent. Then in my PhD, so when during the PhD when we done all the works, my head put only two conditions. The first condition was I want this paper to be accepted and you should present that paper into the one conference that was in the USA. If your paper is accepted in that conference, I'll award a PhD degree. That was the first condition. Second condition that your topic or outcome should be patentable. If you are going to file a successful patent, then I feel like your PhD is done. So in IIT, only with one conference paper I got my PhD degree. And I did my PhD from IIT Roper, which was the second generation IIT. And my patent was the first patent which was done by our IIT Roper. So this is how I come to the patent filing procedure. So that time we didn't have any kind of attorney. The patent was written by myself only. I went to the patent office and I did all the procedures. So later on, then when APR come up, that time we hired an attorney and then we got that patent. Last so it was almost 2018 we filed that patent last year. So it took almost 5 years to get that patent granted. So this is the things which I learned during that patent filing procedure. So that's only I am sharing today. So it is okay if I'm not going to use this mic because it's wasting the moment. So I hope morning session was very good session. It was conducted by the other attorney. I know him personally because he's the expert in the patent. He's a patent advocate attorney. So we might have gone through this what is the property right, what is the type of the rights. So I'll just skip that portion. So we talk only about the patent range because out of this all the IPR patents which is most important among the IPR that each and every company is doing. Okay. So what is the IPR? Can anybody tell us what is the intellectual property rights? Or what is the intellectual property? Any guess, any random answer? Suppose you are having the idea, which is something very much unique, and you can see that if you implemented that idea, certain product or certain process can come up, and it will give some potential economic benefit to you, as well as it will have some societal impact. Then that idea contains some value. That is not physical idea, not physical product, but that idea per se is your intellectual property. So that is the meaning of intellectual property. And rights, ownership of that idea is a IPR, intellectual property right. Now what is my patent? So out of all these 8 IPRs, patent which can give something, it talks about the ownership of that idea. So by implementing idea, only you can generate that product, only you can sell that product. Also, you can sell that idea to some company and you can earn a royalty out of it. So that is the idea behind the patent. So suppose if you are an inventor, if you are having some idea, but you don't have capacity to set up any manufacturing plant for that product, you can sell your patent and you can expect royalty from that company. So this is how the patents give your core right over that idea. So that is what we call as a patent. So there are 3 criteria mainly. The patent should be novel. Novel means it should be unique on the entire globe, not only India but on
on the entire globe, entire world, your idea should be unique. Then that will be called as a novel idea. Second, it should be non-obvious. What is the non-obvious? काही आयडिया आणि असं केल्याने असं होणारच आहे. So that is the meaning of obvious. So that should be non-obvious. But it must have an industrial application. जर ती आयडियाचं industrial application नसेल, then that not fit into the criteria of the patent. So generally patent process कशी असते from the file to the grant. When you created certain idea, you go to the patent office, you file application that this is my unique idea. You will be ownership of that idea. Then they will examine your process, you examine your product, and they will give a right of the patent. So that is called as a grant of the patent. So during that process, they will check all these three criteria. So if they have any objection, they will give some reports stating that these are the three clauses are there and you are not fulfilling that clauses. Then in the next step, you have to give counter argument to that clause. No, our idea is a novel. You are satisfying these three clauses. Please give us a patent. Once you satisfy that these criteria only, then you can get a patent. So that's why this stage are very much important stage. I will show you how they give counter argument to your patents. Then you will get an idea. You have to counter arguments then. Okay. So what is my inventive state? It should have some technical advantage. Technical advancement should be there. For example, let's say you are having a mobile phone. Suppose assume that somebody has invented 2G technology. Now it is having some advantages, it is having some disadvantages. You come up with the 5G technology which is having better speed, some technical advancement has been done, then that's fulfilling the criteria that there is a technical advancement. Second, it should also having a significant implications. What happened after the 5G? Market share of that company was increasing. So that economic significance also had, and that innovation was not obvious to a person's skill in that art. So that innovation is not related to the skills. Now what does mean? Suppose एखादा कुंभार असेल आणि त्याने पॉट तयार केला आणि डिपेंड अपॉन हिज स्किल. तर असं होऊ शकत नाही की मला माझ्या स्किलमुळे हे तयार झाले, ही शुड गिव्ह मी पेटंट. नो. Idea behind that, it should not, why should not be related to this skill? Because when you want to go for industrial application, that product should be manufacturable and anybody can be manufacture that product after you licensing it. So it should not be related with this skill. When you satisfy these three criteria, then you meet the criteria of invention. So when innovation we can call, it should be having technical advancement, economic significance should be there, and it should not be related with the skill of that person. Next slide. An industrial application means, as I said, it should be capable of being made or used in any kind of industry. Then only it will be called as it will having a industrial application. So what is the patentable? Product can be patentable. Example, your mobile phone, Apple phone is a patentable product. Samsung phone is a patentable product. Apparatus for producing a product. For example, any machines which can manufacture mechanical product. So that is also patentable. Process also patentable. For example, manufacturing process or chemical process. So this process is most importantly in the pharmaceutical industry because you are having some chemical reaction by using two kind of mixture, using this temperature, using this apparatus, you can make a product. So that process can be patentable. And composition of matter. Example again, pharmaceutical industry. What is the drug? Basically, it is certain kind of chemicals. So those can be patentable under this category. So there are four types of patent you can get. It should be product, or it should be apparatus, or it should be process related with the manufacturing, or it should be certain kind of composition of matter. In simple terms, it should be some chemical or it should be some compound. Even novel metal or alloy can be also patentable. So these four things can be patentable. Next. Now, what is not patentable? Computer programs, example algorithm or code, that is not patentable. That can be copyrighted. Suppose if you are a programmer or coder and you develop an algorithm, then that algorithm cannot be patentable alone. It should be falls into the category of copyrights. But if your program is coupled with some hardware, then it is a patentable. So if you are from the computer department and if you want to get a patent on certain things, computer program, if it is coupled with the hardware, then it can be patentable. Only computer program it will not get patent. It will be, you can get a copyright on it. Then medical and surgical equipment, that is not patentable. Why? Because government says that if your invention is related with the medical application by which you can save the human life, then it should not be patentable, even it should be open to the public. Mathematical methods, no, it is not patentable. You can go for copyright. Business method also you can go for copyright. Discovery, aesthetic creation, also not patentable. Aesthetic creation why not patentable? Because it is related with the skill of that person. New species, plant or animal, because that is not invention. That is was body in the nature, so you cannot claim it. The invention which are related to contrary to moral standards, not only product. So some unethical products which are not also patentable. For example, weapons or weapon of mass destruction also not be patentable. Invention related to the atomic energy. For government interest, it is not patentable. If you file something related with the atomic energy, government agency will come to you. They will say it is not patentable, but transfer that technology to us and we'll pay for it. But don't go for patent. Why it is saying that? Because when you file a patent application, your patent will be there in the public domain. So anybody can read that patent. Patent is not secret document. When you file a patent, it will be go for the publication so that everybody can read it, and if they have certain objections, then they can approach to the government saying that this is not novel, this is my idea. So everything goes into the patent office or patent application, it will be go for the publications. So something related to the atomic energy which is having some implications on the national security, the government feels that it should not be go into the public domain. That's why they are saying that patent is not applicable related to the atomic energy. So generally means that the patent means it is very much secret. It is completely wrong. When you file certain patent application, it goes to the public domain. Why? Because suppose I am having some idea and somebody has steal that idea and you file patent for it. So I should get equal opportunity to disregard that patent. So government saying that this is my patent journal, this idea is in the public domain. It will be there for 18 months. In the 18 months, if somebody approach to the government saying that, and if they prove that this idea was mine, this is not novel application, then government reject that application. So any patent is not secret. It is in fact made open to the public by government agency. Now, most important part while filing the patent application is the drafting part. ऐसा नहीं कि पेटेंट के लिए बस लिख दिया गवर्नमेंट के पास सबमिट हो गया ऐसा नहीं होता. So there are some specific format of the patent filing. एग्जांपल जैसे रिसर्च पेपर का जो फॉर्मेट होता है वैसे भी पेटेंट का फॉर्मेट होता है. If you are not following the format, then your patent application will get rejected. So government has nominated some format. You have to strictly follow that format. So before the drafting patent to get satisfy this criteria, there are some checklists that before drafting you should conduct search. कभी कभी ऐसा होता है हमारे दिमाग में आइडिया आती है पर वो आइडिया और कहीं पे एग्जिस्ट होती है. So हमारा टाइम वेस्ट ना हो जाए और गवर्नमेंट का भी टाइम वेस्ट ना हो जाए. For that purpose we have to do some search, literature search. Basically you can Google it, you can refer journal, you can see that अगर सर्च में अगर ऐसे कोई एप्लीकेशन है जो ऑलरेडी पब्लिश्ड है एंड इट इज मैचिंग विद योर इन्वेंशन जैसे दैट we are not doing research and already information is available, so we are rejecting the application. So to have a security or to have a confidence in ourselves, we should go deep in the search. Then in this prior arts, there are some ideas which are related with the our product, which are related with the our innovation, but it will having our innovation having some advancement over that their ideas. So, for sake of clarity, you should mention that okay, these are ideas available. So, those available ideas are called as a prior art. In the next paragraph, we can mention why our idea is difference, having some difference with the existing ideas. So that we have so that is called as interesting problems in the prior art. Prior art means there are some ideas which are related with the our invention. Then what is the novelty? You have to explain what is the novelty in the pattern. Then we have to mention the type of application. Type of applications means whether this idea is applicable to the which field. Whether it is applicable to computer field, electrical field, mechanical field, or pharmaceutical field. So that we have to mention. So once you file that patent specification, this your draft is called as a patent specification. It will be read by patent office because they have to verify it, they have to examine it. It will be read by the assignee or technical person, skill person, your competitors, commercial player, and general public. When I was in the company, when we filed the patent, our patent was read by many of our competitors, and they sent a letter to us and letter to the government saying that this idea was already existing. Please don't grant the patent. Why? Because of the market competition. If you are having a patent on certain product, your competitors cannot copy that product. So that's why your competitor always try to restrict your patent applications. So that's why commercial player will play a significant part in that process. And general public because it is a mandate that it should be available to the public domain. Code. Why code? Because if somebody people approach the government offices also, patent offices also, and some people approach to the code also. Biggest example is Apple and Samsung. Samsung, it was a case in 2000, I guess 2007. Samsung has filed some patent and it was read by the Apple and there was dispute filed into the court saying that that invention was related with the us. So eventually code also has to work with the patent application. That's why I mentioned that code is also ready for application whenever somebody approaches to the code claiming that please don't grant the patent. There are two types of the applications. One is a provisional and another one is a complete. I'll tell you what is the difference. Suppose you are a researcher, you are having an idea and you think that your idea is novel, unique and is having some industrial application, but you have not developed that idea yet. But you are confident that within a few months of time you are able to develop that idea, develop that product. But you also feel that this idea should be protected because of certain reason. For example, let's say your colleague should not be clear that this idea is mine, or this idea should not be get leaked and should not be going to public domain. So there is a provision. So you can draft a rough patent application and you can submit to the government patent office saying that this is my provisional application, this is not foolproof yet. Give me some time, within a 6 month period of time, I'll get a complete application. So that application is called as a provisional application. So once you file the provisional application, you are securing first thing you are doing that you are securing your idea. Then within a 6 month period of time, you have to write a complete specification. If you are failed to write a complete specification, then your patent will automatically get collapsed or will get these are the provisions that either you can go for provisional application where your idea is not solid, you are in the process, then you can go for provisional application, or you can go for complete application when everything is done, your product is already into the prototype phase, then you can go for complete application. So patent specification consists of main two parts. One is the description, which discuss about the invention, and claims. Claims means exactly what you want to patent. For example, let's say I am having a this kind of what I can say projector, like I pointer. Okay. Suppose I am having a this pointer. So in the market there are many pointers, right? I will not get patent on the description. I will get a patent on which thing that this pointer consists of these three types, which are itself unique, and this is using such kind of technology where remotely consider that the market मध्ये technology which is using Bluetooth technology, and I am having this pointer which consists of which are using Wi-Fi technology. So your patent will grant on Wi-Fi technology which I use in this pointer, not on the pointer itself. कारण की प्रत्येक pointer मध्ये बटन आहे, पुढे तुमचं लेझर लाईट आहे, अजून या ठेवायला काहीतरी अरेंजमेंट आहे, त्याच्यावरती तुम्हाला पेटंट नाही भेटणार. पेटंट त्याच्यावरती भेटेल what uniqueness your product is having. That uniqueness is Wi-Fi. Your pointer is work on the Wi-Fi, not on Bluetooth technology. So that Wi-Fi will call as a claim. इथे मी claim मध्ये लिहिणार आहे ना, I want patent on this technology in the pointer. That is called as a claim. So most important part, description is not very much important. Your patent will grant only on the claim that defines the boundary of monopoly. So claims is nothing but boundary of monopoly. What is my boundary or monopoly? This pointer using Wi-Fi technology. So that is my monopoly, not laser light or this switch. So my patent will grant on the claim. Claim mode. Next. So description मध्ये काय काय? First title. जसं research paper मध्ये असतं title. Then description of invention. First thing is field of invention. That this invention is related to which branch. Background of invention. How you invent this product. So you have to give some background. Now what are the product available? For example, let's say this pointer. So I write my field of invention is a pointer which used for PowerPoint presentation. Background of invention, there are various pointers available in the market having a very high cost and having very big design. I am coming with a certain pointer which is having using this kind of technology which was not available into another product. So you are setting up a background. Then prior arts. You can say that this company having this patent product using this technology. So that is the prior art. Here you have to mention summary of invention. Then you can say that though various products available in the market, my patent, my product is different from other product with respect to this aspect. So that is the summary of invention. Then you mention detailed description. Detailed description मध्ये you can mention, you can give a figure that this pointer consists of this much length, this much body, made up of this material, having the arrangement so that you can put it in the pocket. It is having on off switch. So everything you have to mention in the invention. Then detailed figure you have to give. And then finally claims. Claims मध्ये तुम्हाला द्यावं लागतं की तुमचं पेटेंट कसं डिफरंट आहे. So that things go into the description. Then there are certain rules for the title. It should be very concise. It should cover all your major aspects, and it should reflect product, process, or apparatus. Next. Example, suppose I am having a ball, that is my invention cricket ball. I cannot mention magic ball for cricket. I cannot mention. If I mention it does not reflect anything. I can mention a novel ball for cricket. there is a limit. Your abstract should be within 150 words. If you overdo out the invention, controller can amend abstract if needed. So when you write the pattern, if you go to the controller and if you feel that certain modification has to be done into the abstract, you will get back to you saying that you should modify the answer. Then in the description, it should reflect what is the novelty, what is the initial state. There should be no ambiguity. Means if and but you should not use into the language. Should fully explain the problem and how you are going to solve this problem with the example. That has to mention into the pattern application plus industrial application. So this all the things you have to mention into the description. Your pattern only will granted when you are solving some technical problem. That's why your description should fully explain the problem and how you are going to solve this problem with the example. Next. So always start your pattern with this wording, the present invention relates to. So when you write the sentence, the present invention led to, it will be automatically leading to the field of invention. For example, this was my pattern. I was developed some cutting tool for machining process. So I mentioned the present invention related to method of reducing friction in machining and tool application by using surface texturing of cutting tool surface. So here I explain everything in a one line that my application is related with method of reducing friction using surface texturing of cutting tool surface. So I define my field of innovation, I define my summary, and then I mention the background. So background, why basically you have to mention what problem associated with your field, and then how you are going to solve the problem. Next. So in this summary, after field of invention and background, you have to mention the objective of your invention. So the principal objective of invention, you start your line saying the principal object of invention is, or another objective, you are having multiple objectives, then you can add another line. Another object of invention is, and if you have further objectives, you should write stating further object of invention is. So these are the some unwritten rules. Those rules are not written in the patent law, but if you write these rules, then there are chances that your patent application will be granted easily because it's restricting. It is not enough. The wording in automatically restrict करता है. तो तुम्हारे त्याच्यापर्यंत घेऊन जातात. They are different करतात. Next summary. At the end, you should write according to innovation code and operator consisting of. So this is an example. end मध्ये तुम्हाला summary द्यायची आहे. Then detail description. Description मध्ये तुम्हाला mention करायचे त्याचे parts असते. With the help of figure. Right? For example, this was the figure. So I have mentioned the different parts of the figure with certain numbers. That numbers you have to mention. And then in the description, you have to mention that one is circle 1. Then ship was also one part, that's 2. Then right surface another part, 4. So when somebody is reading your application, he will correlate this number with the figure. So that's why you have to denote the numbering into the figure. And last is a claim. It is the most important aspect. You can make many mistakes in the description, but you should not make any mistake into the writing the claims. When I find the pattern, I claim 18 weeks. I return 18 claims. Now they took objections on the claim. Finally, I have to reduce my claim number from 18 to 9 only. So this is how you have to start. I always start your claim with I if you are a single inventor, or V if your innovation having more than 2 inventors. Okay. Other claims you can type dependent claim. Independent claim refers to the standalone claim that contains all limitations. For example, एखादा main claim आहे आणि त्याच्या associated with the various claims something, then that is called as a dependent claim. But एक claim वेगळा आहे and there is another claim which is having no relation between the two, then that is called as a dependent claim. पेटंट करायचं तुम्हाला जर विचारलं तर तुमचं independent claim आहे का dependent claim आहे, that is for our understanding. So here these are the my claims. So we basically do inventor, me and my supervisor. So we start with the three claims. Then we identify what are the essential features in the claim आणि त्याच्यानंतर बाकीचे claims होते त्याच्यामध्ये some feature दिले. Example बघा, this is claim number 1. It is that everything. Then claim number 2 says that according to claim number 1. त्याच्यामध्ये मी काय करतोय, claim 1 ला associated बाकीचे माझे जे काही सब फीचर होते ते मी खाली लिहितोय आणि स्टार्ट कशी करतोय according to claim number 1. So these are all my dependent claims. So this is how you have to write down your claims. Example, I am having a car and I am claiming that I have developed a roof for the car which is something very much unique, which is made up of vinyl material. So this car with the vinyl roof, that is my claim number 1. आतापर्यंत अशी कार कुठलीच नव्हती की जिचं रूफ विनाइलने बनलेलं होतं. So that is my first claim. Next, further, this car consists of vinyl roof and roof is with black in nature. So here my this second claim is depend upon claim number 1. So these are the independent claim. Now suppose I am having another feature into that roof. Next slide. The car of claim number 2 further compromising rain guard attached to the state roof. So this is the additional feature. So that also I am putting in a claim number 3. So all these claims, claim number 2 and claim number 3 are dependent on claim number 1. So this is how for each feature I have to write down separate claim. आता याच्यामध्ये ॲडव्हान्टेज काय आहे की समजा विनल रूफ पहिले नव्हतं, आय गेट अ पेटंट. सेकंड मध्ये विनल रूफ होतं पण ब्लॅक कलर होता, मग पेटंट काय म्हणत नाही हे ब्लॅक कलरचं आहे तुम्ही हे काढून टाका, विनल रूफ आहे. किंवा हे दोन पेटंट होते आणि रेन गार्ड नव्हतं, रेन गार्ड दुसऱ्या पॅटर्न मध्ये होतं, तर काय म्हणत की दोन क्लेम पास आहे, थर्ड क्लेम रेन गार्ड प्रत्येकाला आहे हे होतं. So this is the advantage you are getting if you are filing the claim for each feature. If you write into the one claim, त्याच्यापैकी एक जरी फीचर प्रायोरिटी सापडला तर सगळा क्लेम जातो. त्याच्यामुळे फॉर प्रत्येक फॉर each features you have to write down separate claim. Whether it should independent असं त्याचे प्रॉब्लेम नाही. काय प्रॉब्लेम not compulsory. फक्त independent part मध्ये असं आहे. Dependent claim मध्ये काय आहे, your first claim is should be very much common. जर तुमचा पहिला क्लेम गेला तर सेकंड आणि थर्ड दोन्ही क्लेम जातात, कारण की it is depend on the claim number 1. So if you are very much sure that this feature is something very much unique, then you should write on the claim number 1 and you should make a dependent claim. Otherwise you should make an independent claim. मी माझं ॲप्लिकेशन दाखवतो, त्याच्यामध्ये मी 18 क्लेम केले होते. पहिला क्लेम 18 क्लेम केले होते. पहिला माझा मेन क्लेम होता, त्याला सब फीचर्स होते 8 आणि दुसरं मी टाकलं होतं की माझा समजा पहिला गेला तर दुसरा मेन जो क्लेम आहे तो राहिला पाहिजे. म्हणजे माझे 9 जरी गेले तर शेवटचे 9 माझे पास होते. पण त्यांनी काय केलं, पहिला जो दुसरा जो मेन इंडिपेंडेंट क्लेम होता तो त्यांनी काढला. माझे शेवटचे 9 गेले पण पहिले 9 राहिले. drafting a patent or drafting a claim is a art and it should be strategically drafted. Next. Then while drafting a claim, certain methodology you have to adopt. You should not write in a very casual manner. One example I'll give. Okay. Suppose consider table was not existed till date. I invented table. Now table consists of 4 lines, 62 and 1 column. Right? You should not write like this. For example, only bracket certified. Now it consists of game device consists of apparatus, portion and protrusion. Okay. So these are the part of the bracket. Consider that first time I am inventing this bracket. I should not write like this. I should write in a very academically manner. A game device compromising handle or a portion connected to the handle and protrusion being secured to the handle. So basically you should not mention just simple parts of your product. You should make it clear how this part connected with each other. So that's why you should not write like this. A game device compromising handle, head protrusion and protrusion. You should like that. You should connect all these parts so that you can get a clear idea. A game device compromising handle, head protrusion connected to this part handle, and it is further connected, further secured to the handle. So this is how you have to write down your claims. So claim is a very much important part in the drafting of patent. You can make a lot of mistakes into the description, doesn't matter, but your claim should be written in a very specific manner and it should give clear picture to the patent attorney. So this is how you have to write down the claims. So when your claims are ready, then you can go for filing your application. So in India there are 4 offices. In the 4 offices, electronically on the internet, you can file your patent process. So there are few processes. First, apply for the patent. There are some forms are there. Form number 1, form number 2, form number 3, form number 5, form number 16. So these many forms you have to write here. And these are the very simple form which is available on the website. Then electronically you have to file application. Then it will be go for the publication. It will be there for the publication for 18 months. So it will be made available to the public. Why will you go for the publication? To check uniqueness. गवर्नमेंट काय करते आहे गवर्नमेंट खूप हुशार आहे ते स्वतः सर्च नाही करणार ते पब्लिक डोमेन मध्ये डिस्प्ले करते आणि ज्याला ऑब्जेक्शन आहे ऑटोमॅटिकली पेटंट ऑफिसकडे जाईल काय these are our application our objections. Then after receiving the objections, it will be go for the examination. It will not go for automatically for the examination. You have to go. You have to file another form saying that please go for the examination. Why? Because after publication, if you feel that okay, these many people have taken objection and it come to my notice, my invention is actually not novel. So I can leave that. It doesn't matter. So this basically this strategy used by the government office. Why? Because they don't want to get overburdened. So if you are not interested, then you are not going to file another application. If you are genuinely interested, then you are going for the examination. So they said that if you are really interested after the application, then pay the fees and go for the examination. Then your application will go for the examination. They will do literature search. They will Google it. By their end, they will try to get prior arts and they try to reject your applications. Okay, don't consider that they will support our application. They try to reject your applications. Why? Because they have to maintain the novelty. Novelty gone the moment it is actually existed in the market. Then if they have any objection, then they will issue first examination report. So after examination, they will issue first examination report stating that on these 3 criteria, your application application is not unique, it is not novel and doesn't have an industrial application. So based on this ground, we are rejecting. Further, they say that these are the priors, your application, your idea was already there into the public domain, and because of this, we are rejecting your application. If you have any further clarification, please get back to us. If you are not getting back to us, your better application will be automatically get rejected. So you have to reply that examination report stating that no, our application is novel. Though you have mentioned the paragraph, but these are paragraphs not related with our innovation. That's how you have to mention. And then finally, if they are satisfied, then only your patent will be granted. So this is how patent application process works. So generally, in my times, in 2000 till 2020, it took almost 4 to 5 years to get a patent. Now there are various schemes are available for which you can get patent within 45 days. So that's also not possible. So this is the one example of how to get examination report from the patent office. So this is my patent, and this was the name of IIT Roper. Applicant was IIT Roper, inventor was me. So they wrote to the IIT Roper that we examine your patent application and there are some objections associated with it. So I open my API report and I show it. Escape करना, escape करना, okay, so that is not there, but I will show it. So here they will analyze your patent based on these three clauses. When your patent grant, it basically grant on the three criteria. Novelty. So they will say, okay, claim number one, whether it is novel. So they are saying yes, it is novel. Inventive steps. Claim number one to again they say no. Okay. Novel है, but it is not inventive steps. Inventive publication, yes. So in the my first examination report said that you are meeting the two criteria, but you are not meeting one criteria. That's why we are rejecting your applications. Okay. Then they are saying that on which criteria you are rejecting application, not getting. Specifically, unity of invention, only one and that is inventive, otherwise not inventive. So in the first examination report, they said that okay, you are not meeting one criteria, we are rejecting your applications. Plus, they are giving the priors. You know this slide, this science, this slide. So here they have given a prior saying that your application patent idea is already described into D1, D2 and D3. Document number 1, document number 2 and document number 3. So these are the three patents was existed which are matching with my patent and saying that your application is a novelty, having a novelty but it lack of invention because it was already mentioned into these patents. And also they are giving the references, claim number, everything they are giving. Can you go? So they are explaining why your application is being rejected, referring document number 1, document number 2. So they study your patent, they study the prior and they get back. They get back to you with detailed explanation. Next slide. अगर कोई रफ वर्क किया है आपने पेटेंट का जो एग्जाम करता है वो भी भेजता है इसके साथ. So everything is very much documented. Next. So you have two choices. First choice, view the application. You are not interested. उसको रिप्लाई मत करो, ऑटोमेटिकली आपका एप्लीकेशन रिजेक्ट हो जाता है. Otherwise, make changes into your application. Next slide. And respond within a 12-month time after issuing your first examination report. Next. So what we did, we basically given a reply to them. We actually made a PPT saying that this is our application and your document number 1 is related with something else. Your document number 2 talking about this, but we are not talking about that. So that's how we made clear to them that this our application is not related with document number 1, document number 2, document number 3. And they mentioned the claim number also that your claim is called inventive. So what we did, we removed the last 9 claims. त्याच्यावर त्यांनी ऑब्जेक्शन घेतलं ते क्लेमच करून टाकलं. पहिले कंटिन्यू क्लेम ठेवलं. So now it doesn't have any objection on that and we get a patent after few days. So this is how patent application works. This is how the process has been followed. So earlier it used to take a lot of time, but because of these, you can say that new government they made some rule, they having some scheme through which you can get a patent at a very after. So this was the typical timeline. So filing of the complete specification, it will be go for the public domain for 18 months. Then within after 18 months, within a 1 month period, you have to write up one line saying that go for the examination within that 48 month. And after within a with 20% of fees of original. Only suppose पहले अगर 10,000 पे करके तो पहले 2,000 में कम हो जाता है. Then we can go for early termination process. You don't have to wait for a 6 month of obligation. Very much fast. You can go for. You can tell that within a 1 month period of time. You also examination report. But it is having some criteria. First, you should have a startup status. Second, you should be a small entity. What is a small entity? Basically, you should fall into the MSME category, medium small scale industry, or one inventor should be woman, or you should be in the government department or government requirement should be find that better, or government overall control institution like us, because we are ultimately controlled by the government. Government finance institute, that also education institute also they benefit, and some notified sector by the government. So if you are a startup or small entity or one of the inventor is a woman, then you can get a better and very much faster rate with the subsidized cost 20%. So this is the government initiative has been taken. Next slide. So if you meet this criteria, then you can get a this is the advantage of having a startup and small entity. There is another scheme called as the SIP scheme, Startup Intellectual Property Protection Scheme. Basically, मेरे प्रॉब्लम क्या होती थी कि पेटेंट ड्राफ्ट करना कैसा उसमें मुश्किल. Then you have to hire a patent attorney. He will charge a very high amount of fees from you. You have to pay that fees. Then he will file an application on behalf of you. And at every stage you have to pay a fees. Everything is depends upon the advocate. So a lot of ideas was not getting patented because of the financial issue. Because others cannot take the burden of paying the very high amount of charges. Plus, as an education institute, you're not supposed to be paid with that high amount of charges. So what government is saying, okay, you are having the idea, that is fine. We'll provide an attorney to you, and we'll pay charges to the attorney on behalf of you. You don't have to pay anything. Government patent attorney fee shall not be paid by the education institute or the startup. It will be simply borne by the government. What we have to pay? Only statutory fees. That is a minimal amount. Only 20% fees you have to pay. So what they did? They actually enlist facilitator. This attorney they listed on their website. We have to approach the facilitator, or they will give us a attorney saying that you work with them. That attorney write a patent on behalf of you. Everything will be done by the attorney. What are the charges of the attorney will be borne by the government itself. You have to just approach and you have to just pay your minimum statutory fees. So that has been provision made by the government. So if you are having a startup or if you are having some idea, first form of startup, and through the startup approach to the SIP scheme, approach to the facilitator, and everything will be done by the patent attorney. Patent attorney will be taken care of by the government. तो उसके लिए क्राइटेरिया क्या है? एक तो स्टार्टअप होना चाहिए, या वन इन्वेंटर शुड बी वन, और इट शुड बी फाइल ऑन द बिहाफ ऑफ एजुकेशन इंस्टीट्यूट टू प्रूव इट दैट some fees or something you are getting benefit from the government. So these are the earlier fees. Natural person pays 100,000. If you अगर फाइल करना था तो 8,000 charges होते थे. But now, next slide. Natural person startup education institute has to pay only this much amount of fees. You can see the difference. 1,600 and 8,000. So this much difference has been there because of these schemes now. So this is how the patent drafting has to be done. Claims, systematically you have to write down the claims, and these are the many schemes are available. Okay. So this is from my end. If you have any doubt, you can please ask. Any doubt? So this question was not related to the patent, but this is related to some industry. Now, why? If you see now, R&D people are very less in the industry. So R&D department consists of only comprising only 5% of the manpower, right? So first you have to prove that you are worthy of R&D. Then you get us to patent the R&D, right? So for that purpose, what you have to do in the graduation itself, you should start writing a patent. First thing you have to develop ideas. If you are able to write a patent, then while hiring, any company will say that okay, he is a fit into the R&D position, he will hire in the R&D. That's how we can get the benefit by writing the patents. Any benefit of the IIC? Can you transfer the ongoing patent to another? Inventorship not possible, but you can license the patent. You can say that I am giving the license to this company or this person, and I am charging a fees order my license. So patent as such cannot be sold, but you can license that patent. What decides grant of the patent? First, it should be novel. Grant. Okay, if you are a natural person, within a 10,000, government fees, everything will grant. It is within 10,000. But why it will become a costly? Because if you attach attorney to it, attorney fees are very much high. For drafting one patent, they will charge something around 10,000 to 15,000 rupees just for drafting. Remaining charges are extra. So better go for SIP scheme. So the scheme government will award you attorney or can select the attorney. Government will pay the fees. You have to just pay the order the minimum fee spent by the government. That you can do. So patent is if you apply, if you everything is done by yourself, that is within 10,000 you can do. But I'll always recommend that you should hire an attorney because when we drafted ourselves, but at the time of FAR report, automatically we thought that okay, we did some work here, then we got it because attorney professionalism is because they are expert. Their daily job is writing a drafting a claims and patents, so they know their stuff very good. उसको ऐसे नहीं कर पाते, so attorney हमेशा अच्छा होता है यहाँ पे। और उसका प्रॉब्लम के चार्जेस को उठा लेता है। But I are in SIP scheme के clause, patenting attorney fees will be paid by the government. Vijay Kulkarni is one of the nominated facilitators. Is there any restrictions that in how many words you have to write the description of so it is not their kind of restriction, but there are charges. If your patent application is more than certain number of pages, for each page they will charge additional money. So you have to pay additional money for how many papers you are using. Plus there is limitation on the claims. For each additional claim, you have to again pay more number of, you have to pay additional charges. So there is no such kind of restriction, but they will put a restriction in terms of money charges. So in our case, we had a 80 number of claims. So I guess limitation was up to 10. So for 9 number of claims, we had to pay some additional charges plus pages was more. So the patent number it should be fall within a 10-15,000 rupees is going to the time different था तब गवर्नमेंट स्लो थी अभी गवर्नमेंट फास्ट है तो one case is there they grant patent after filing they got their grant certificate within a 45 days so that is possible so within a 6 month time you can say that you can get a patent if you go with if you are having a startup one inventor is over then you can get a fast that is possible okay I can say
Yes.
so one tip I can share with you suppose you want to become हाँ तो simple way क्या है कि how to write a pattern basically download pattern related with your field or related with your ideas at least down 8 to 10 patterns which are granted and start reading those patterns इससे फायदा क्या होता है एक तो आपको उनकी लैंग्वेज समझ में आती है टाइप कैसी होती है वो समझ में आती है फॉर्मेटिंग कैसे करना है वो समझ में आता है then you start to write your own patterns that is a much better idea while drafting the pattern and go for original specification first because it will secure your idea then within a 6 months run time go for complete specification so that you can do एक चीज आपको करनी है there should be individual agreement or understanding between the inventors and the applicant. For example, in our case, in IIT, there is a rule that whatever the revenue generated by the vendor, 60%, I guess 40% will be taken by the IIT and 60% will be shared among the inventors. तो वो पहले से आपके पास अगर उसका रूल्स है तो अदरवाइज that policy है जो draft कभी कभी बहुत सारे लोग क्या करते हैं कि पेटेंट मेरा नाम डालो बस करने का because it's generally not in my case I was having a two supervisor one supervisor was not active not interested no supervisor I don't have position under one supervisor so when we file the patent with his name it was okay it's fine so you should be very much clear because whatever the revenue is getting it will share after the investors तो वही चीज आपको करनी है दूसरा चीज ड्राफ्टिंग के टाइम पे नहीं बट आई विल सजेस्ट in my case what we did we hired attorney at the time of examination तो हमारे जो ड्राफ्टिंग के चार्जेस थे वो बच गए हमारे एसएससी में कुछ बजट होता है उसका बजट पेमेंट करना पड़ता है so we said that in your case what you can do आपके पास IIC सेल है you form a startup under IIC सेल उसमें एडवांटेज क्या मिलेगा एक तो आपका पेटेंट जल्दी लैंड होने के चांसेस अच्छे हैं सेकंड you can take benefit of this government scheme okay so instead of paying very high amount of charges restrictive charges instead of paying 8,000 rupees you can file an application within a 1,600 rupees that is a possibility plus you can save fees on the attorney so that you can but मैं तो फ्री में मिल गया take the benefit of it that's it was स्टिल कर लेता है, आईडिया स्टिल कर लेता है, सॉफ्ट कॉपी में, so you can claim it invitation that this is restricted area for the public area and somebody has still our application. So this is where we have to do it. That's why in the company you can see that ICAR system is very much important. Why? Because they want to maintain secrecy. In some area only selected persons are allowed. Especially in the case of R&D offices, only selected persons are allowed. Why? Because they want to maintain secrecy. Another reason, they want to maintain secrecy about their patents. So these small things we can take care of since the beginning. जब तक आप application file नहीं करते तो पेपर मत निकालो. पेपर निकालते हैं, पेपर निकालने के बाद हम पेटेंट फाइल एप्लीकेशन, तो आपके पेपर आपका प्रायर बन जाता है. What we did, we first file a patent, we wait for publication, and then we publish our patents. So our whole paper work become a prior. हमारे अगर या हम ज़्यादा कॉन्फिडेंस है तो हमने क्या किया कि तो वो पेटेंट अभी मेरे कॉन्फिडेंस के ऊपर ही पहले से बाकी चीज़ें हमने डाली नहीं, मतलब डालने जरूरत नहीं, जरूरत नहीं. फर्स्ट वी फाइल अ पेटेंट एप्लीकेशन एंड देन वी स्टार्ट पब्लिशिंग योर रिसर्च आर्टिकल्स बेस्ड ऑन योर आइडिया. दैट इज द सेफेस्ट वे. पेटेंट एटर्नी नॉट गोइंग टू डिफरेंशिएट, वो नहीं देखेगा वो नाम किसका है, वो बोलेगा अभी का पेपर आपका पैरा बन जाता है. पहले से पब्लिक डोमेन में, इट इज इन पब्लिक डोमेन, इट इज नॉट बिकम नॉवेल, इट इज नॉट टू एवरीबॉडी. These are the small things we have to take care. कॉर्पोरेट में क्या होता है, फाइनेंशियल एस्पेक्ट ज़्यादा क्यों नहीं रहते कॉर्पोरेट में. वो कोई प्रोडक्ट नहीं है, इट इज बेसिकली लिटरेचर. राइट, योर नेम इज ऑलवेज आल्सो लिटरेचर. इट इज आइडिया ऑफ इट. ज़्यादा करके इसको फायदा नहीं, हो ही नहीं सकता, उतना पैसा बच सकता है उसमें. बट टेक्निकल क्या है, अगर आपका लीक हो गया तो प्रॉब्लम है, तो क्वालिटी चले जाती है. लिटरेचर में क्या है, बेसिकली इट इज आर्ट, इट इज हैविंग सम डिफरेंट एस्पेक्ट्स, इट इज नॉट लाइक अ पेटेंट. उसमें ज़्यादा कोई इशू नहीं है. सो यू कैन डू इट. इवन फॉर एग्जांपल you can also use the newspaper that some institute has a fine 200 number of copyrights. What they did, they asked us to write an essay. Okay. गायत्री को मेरा पैसे अलग मिला, मेरा लोनावाला पहला लेके गया, 100% तो कॉपी नहीं होता ना. जो मैं लिख रहा हूँ और मैं नॉट टू एक्चुअली I can get easily copyright. Suppose you are having a poet, you can go for copyright. कोई प्रॉब्लम नहीं. So easiest way to get an idea is copyright. Easiest. It is easier than publishing research article. स्लाइड होता है, अगर कुछ रीजन आपने मिस बनाया है उसका, यू कैन गेट अ कॉपरेट फॉर दैट स्लाइड फॉर्मेट आउटपुट also. That is possible. Browser है, browser का format में कुछ तो that can be also cooperated. Your iCard का result that can be also cooperated. So cooperate is a very easy idea. Only thing is people are not aware of it. अब कुछ चीज़ों को टाइप करके भी कुछ तो प्रयोग होता नहीं. That is very simple. Actually, the person who is visiting is a very basically simple person. So some people can say that okay, oh, this is very your mapping is very okay. It's very simple. Suppose somebody know the IPI, you can say that somebody is not having nothing to know the IPI. It's very simple. Patent nobody can deny, but copyright, you can say that it is literature also. They can also take it on the basis of it is not related to the technology or something. So simple. But depend it. It is just like your fuel. I can say that your fuel is not working. Somebody can do it. Somebody say that this fuel is not working. Somebody can say that this fuel is not working.
Thank you, sir. Now I request Dr. Vaishali Reddy ma'am to give it over to Dr. Sir. Thank you, ma'am. Thank you, sir. Once again, I thank you, sir, for enlightening and guiding us through this session. Last but not least, I thank all the faculty members and students for attending this session. Thank you, everyone.
उसके पहले